Thank you very much, Chiga, and good afternoon, ladies and gentlemen. My name is William Field-Papuga, and I would like to welcome you all to the fifth session of our conference, the Digital Services Act Package, Revolution or More of the Same. This time our session will focus on implementation, cooperation, sanctions, and enforcement. So we'll be mainly focusing on Chapter 4 of the legislation. So we are very privileged today to have two very distinguished guests presenting. Our principal speaker is Professor Hans Schulte-Nölke. He is a professor of civil law, European private and business law, comparative law, and European legal history at the University of Osnabrück. He also is a part-time professor at Radboud University Nijmegen and is a director at the European Legal Studies Institute. Our commentator for this session will be Dr. Petra Leupold. She is the head of the Verein für Konsumenteninformation, the Association for Consumer Information Academy. She is also a board member for the European Center for Digital Rights and a postdoc university assistant at the Johannes Kepler University of Linz. And as with our other sessions in the conference, members of the audience may ask questions either by writing them in the Q&A or by raising their hand and having the opportunity to present their questions orally. So these will be presented at the end of the presentation. So without further ado, I would like to give the floor to Professor Schulte-Nölke. And just so that you're aware, you don't have to be co-host to share your presentation, Professor. So without further ado, the floor is yours.
Well, thank you first of all for the kind invitation, and I hope that you can see the presentation, perhaps even myself, and hear me. That seems to be fine. Therefore, well, I was very grateful not only for the invitation, but also that Werner Steng ended with that there are many obligations of platforms in the DSA, which can be sanctions, which is, of course, precisely the subject of this intervention. And if you, look into the DSA, you discover immediately that more or less 50% of the whole amount of articles is on enforcement, which gives, of course, a mission impossible to me. I cannot do much more than introduce some key elements. The structure, I think you are well aware of the relevant chapter 4 is section 1 is more or less on the national level, competent authorities, national digital services, and their competences. Section 2 is on the board, the European Board for Digital Services, and section 3 on very large online platforms and specific competences of the Commission. I will skip the leftovers in section 4 and 5, even though they might be important. Just a hint, a tiny but perhaps a rather important element of enforcement can be found in the final provisions, which adds to the list of EU acts where representative actions are possible, also the DSA. Well, first of all, what are the competent authorities? The administrative enforcement mechanism is heavily based on the member states. Member states are obliged to designate one or more competent authorities, which gives in particular member states to entrust specific authorities for financial services or whatever, telecommunication, with also the enforcement of this EU Act. But in order to get it organized on an EU level, each member state is obliged to designate one of the competent authorities as their digital services coordinator. And if you read further, then you will discover that this digital services coordinator shall act with complete independence. This is clearly the model of the GDPR. And following more or less the same model, a European Board for Digital Services is to be installed. It is composed of the digital services coordinators shared by the Commission without voting right, but well, the list of functions is pretty short of this board. It's coordination and advice, which means as a starting point, we have a decentralized enforcement, which at least in many points follows the model of the GDPR, and therefore also at least may incur some of the problems the GDPR enforcement is confronted with. Well, if you have a decentralized model, you need to clarify jurisdiction, which means which member state has jurisdiction. That's a pretty clear system, nothing to criticize at all. It is the state where the main establishment of the provider is located, and for those who don't have, where the legal representatives, they all are obliged to appoint, is established. That's a clear and simple rule. It follows also the idea of the one-stop shop, which gives, of course, ease, in particular, to platform operators, that they only have to deal with one competent authority. It is unavoidable that this involves a de facto choice of jurisdiction, in particular, of course, for those who don't have an establishment within the EU. They can simply decide where to put their legal representative and therefore choose one member state of jurisdiction. Only the hopefully rare case, if there are providers without any legal representative, which infringe then, of course, their obligation, in that case, all member states have jurisdiction. The real innovation, if you compare it with the GDPR, is that in some cases, only in the course of the enhanced supervision of very large online platforms, the Commission itself gets jurisdiction and the competence to replace the member state with jurisdiction. And as we all know, I put it in brackets on my slides, this is often, if not always, in case of the very large platforms, a very small member state, which has led under the GDPR to some criticism. Well, let's have a closer look on this enhanced supervision system. First of all, it is a two-step approach. Jurisdiction remains, even in the case of very large online platforms, with the member state, but at least the officials of this member state can read some very strong words, what they have to do in that case. They must take utmost account of any opinion or recommendation of the Commission or of the board, and the Commission and at least some member states may recommend the digital service coordinator with jurisdiction to investigate a suspected infringement. And there must be an exchange of information. But in certain cases, which are regulated rather complex, but I can imagine that this might work with also strict deadlines, the Commission itself is entitled to take enforcement measures, which would also automatically lead to the results that the member state digital service coordinator is no longer entitled. We will have to see whether it actually works, but at least it is not from the outside dysfunctional, it could perhaps work. Let's look a little bit closer on the enforcement powers. Of course, now there are two lists of powers, one for the national digital service coordinators. You don't find big surprises there. The national service coordinators have the power to accept commitments of platforms in relation to compliance with DSA and make those commitments binding, which I find a very interesting tool. It is self-evident that they have the power to order cessation. The power to impose fines is even stronger, as we all certainly have noted, as it is in the GDPR, because the cap, the upper limit is higher at 6% of annual income or turnover. And in serious and urgent cases, there must be a power to adopt interim measures. It's perhaps important to see that this list of powers is just you could call it minimum harmonization. It is the powers the national digital service coordinators must have at least, which means that they can have more. And one test case I always, let's say, followed a little bit when reading through the DSA was whether the digital services coordinator can impose on platforms also to pay compensation to injured parties. As a test case, I always had in mind that the platform infringes the know your business customer rule, which then may lead to damage for physical injury because it was a dangerous good, or just economic loss because it was a counterfeit good or something like that. And if you ask yourself whether member state authority can oblige the platform operator by public law means to compensate the injured parties. Well, some national authorities in the consumer law area can at least have some instruments which come close to such a power, but I don't see an obligation of EU law on the member states to introduce or to install such a power. This follows, at least if you read closely, from the idea of commitments. At least you could imagine that a national digital service coordinator uses its power to impose fines in order to make a platform operator to offer a commitment to compensate injured parties. I've seen, for example, that in the Netherlands, something like that seems to be possible, but this would not be, as far as I read, the proposal necessary for all member states to introduce such a power under the Digital Services Act. If you then continue reading, you find, of course, the enforcement powers of the Commission, of course, only regarding the very large online platforms, and you find more or less the same list, only much longer, for the obvious reason that this is not just a minimum, because there is no other level. Therefore, the EU legislator needed to flesh it out on its own. But perhaps the same result, if I read it correctly, that also the Commission would not have the possibility to force the platform operator to pay compensation for damages. Imagine the test case. Imagine a bulk sale of dangerous goods. There are hundreds or thousands injured parties having perhaps personal injuries. Then this administration could perhaps impose a very serious fine But as far as I can see, I hope I'm wrong, but if not, I hope that this can perhaps be added. But in any case, it is worth pondering on the question whether the public enforcement power should have this possibility. If you want to analyze it a little bit and compare it, we have, of course, several models. This, at least, is partially closer to competition enforcement, at least the Commission competences, than the model of the GDPR. However, GDPR already warns us. Many of you will remember that also in the GDPR, in the original proposal, there were more far-going powers of the Commission which didn't survive later proceedings. Let's try to broaden the perspective a little bit, and I'm more or less repeating what I'm very grateful for that Gerald Spindler already said a few minutes ago. Administrative enforcement is only one way to enforce all these obligations. One could perhaps distinguish three layers of enforcement. One, I tried to describe administrative enforcement by the mainly decentralized national system, but with some rather strong powers of the Commission for very large online platforms. Then you could start wondering whether there is something like collective enforcement by stakeholders, perhaps even by civil society. You find some rather innovative elements. Trusted flaggers and vetted researchers could be part of such a structure, and already mentioned, the list is of course not comprehensive. Representative actions could be a very important element. And then of course, individual enforcement, that the individual, for example, injured person tries to enforce such duties against the platform, for example, via a claim for damages, and one would have to solve cases now, check whether this would work, and take my very simple example of dangerous or counterfeit goods obtained via the platform, where the platform infringed the Know Your Business Customer rule, and now the buyers claim damages from the platform for the obvious reason, because they can't trace their seller. As said, I'm not so sure whether public enforcement would help these buyers. Probably these buyers, by the way, should be consumers, because the Know Your Business Customer rule is only applicable towards consumers, but that's perhaps also not an ideal solution. But in any case, imagine for a moment that one individual consumer wishes to enforce such a claim for damages. Then there's, of course, a procedural side and a substantial side. On the procedural side, whether there's an effective complaint handling mechanism of the platform where you can make first this complaint, can, at least in this case, be doubted. ADR, ODR for consumers, of course there is, but I'm not so sure whether the existing structure of ODR, ADR would be capable of dealing with bulk damages in many European countries. Then we end up that this poor injured consumer tries it with the classical court system. International jurisdiction at the seat of the injured consumer, well, probably is there, both under a contract and under tort. A little bit difficult for pure economic laws, but perhaps even there, yes. Clear rules on the private international law, in particular also law of the consumer applicable, yes, most likely both for contract and tort, but then you end up whether there are clear rights and claims substantive law against the platform, and then the big question marks begin. The first question already touched yesterday by Christoph Busch, was whether the DSA shields platforms from this kind of liability. I hope not, but at least it is not utterly clear. Clarification should be very useful, at least. Otherwise, this would be a real contradiction within the Act, imposing obligations, but more or less blocking sanctions in the same Act could be seen as contradictory. But I think at the end, at least the result should be that the DSA does not shield platforms from liability. Next question is, does EU law grant a claim for damages against platforms? Well, clearly not under the DSA. That's never a positive base itself, maybe the opposite. Well, perhaps under a modernized product liability directive, one can imagine that such cases would be covered. And well, the question is, but this would only cover a personal injury, but would not cover a pure economic loss, for example. And well, to what extent is national law a fallback? This is even doubtful regarding personal injury against the platform operator. Christoph Busch already mentioned yesterday, I repeat it here, the very interesting line of case law in California, which comes to that result. I'm not so sure whether many European countries would end up with the same. And therefore, one could at least ask the question whether there is a liability gap in the Digital Services Act. Admittedly, strong administrative sanctions, which will help, but the question whether there are claims for damages in EU law or in national law is doubtful. At least thinking from my own legal system, the first question would already, is this just public law, just market regulation, or is it also, are some of these obligations also protective obligations in favor of private individuals, or at least consumers? For the know your business customer rule, I would suspect that the result would be yes, but for other obligations, this is a broad and open question. Some clarification would be useful. At least there is some hope that all these uncertainties, or at least some of them, could be overcome by some brave actors who bring forward representative actions, because one could test the system. My general plea is that what would you expect if you ask a private lawyer accessing a public law? My general plea is don't forget private law, individual enforcement. This may be a very effective tool. And if you look at the draft, I think that at least the clarification would be useful, that the Digital Service Coordinator and the Commission should have a way to make platform operators pay compensation, of course, in serious cases. I think the most elegant way would be that a clarification that these commitments which these enforcing authorities can accept and make binding can include also the obligation to compensate. And then, of course, the clarification that some of the obligations may, at least under national law, result in an individual claim for damages. Could be pretty useful. You will understand that I point on the European Law Institute model rules for online platforms, which have been even led by this idea that these hybrid obligations of platforms somewhere between public and private law should also be, to the extent that they protect private interests, a basis for liability, and including a claim for damages. The overall assessment is not at all negative. Please don't misunderstand me. I see some substantial improvements also on the enforcement side, but there's still some way to go towards the good combination of administrative and private enforcement that complement and reinforce each other. Thank you very much for your attention.
Thank you very much, Hans. Yeah, well, on that note, I'd like to quickly pass it to Petra for her comments.
Okay, thank you very much. I do hope you can see and hear me properly. Thank you, William, for the intro. Before, congratulations also to Christiane and Nikolaus for hosting this high-class conference. Thanks for having me. I'm excited to be here and to contribute to the sanctions and enforcement part, especially, of course, since enforcement, as always, is at the very heart of whether or not the DSA will have a palpable impact or be mostly toothless. We are scheduled for a hot 5 minutes, so I will make this quick and focus on the consumer protection aspects relating to transactional platforms Werner Steng was already talking about, i.e. know your customer, traceability, transparency, etc. And that also just recently have been subject to a point regulation by the Omnibus Directive. Hans already outlined the relevant DSA rules, shared his views, and I agree with basically all of his conclusions. I especially share his point that the draft undoubtedly is a big step forward, though I am not positive it is entirely equipped to ensure swift and effective enforcement actions to disincentivize efficient breach of law, which is also strongly reinforcing, of course, Gerald Spindler's findings, who already made the compelling point before. It does seem highly advisable to interlink and to flank these new rules with especially unfair competition, contractual, and tort law. Why? Public enforcement wise, Hans already talked about, and also Gerald touched upon it briefly, this cooperation mechanism, the joint procedure providing for a cooperation between national service coordinators and these digital service coordinators and a European board for digital services that resembles the GDPR model. However, our experiences with the GDPR show that this mechanism has not really proven to be an effective and successful tool. There are individual authorities with widely different, often insufficient resources that are supposed to make joint decisions in cross-border cases, with one authority in charge taking the lead, which of course also means dealing with 27 completely different sets of rules on administrative proceedings, because there is no EU-wide framework for administrative proceedings. So far, unsurprisingly, this system has shown to take up years to clarify legal issues under the GDPR, and also to sanction big players, imposing cease and desist orders and or fines. Also, and this is a point Hans already made as well, the DSA facilitates forum shopping because non-EU platforms are free to strategically establish a place of residence of their representative as they see fit. And therefore, basically, you're able to choose also the jurisdiction of the weakest national authority that might not just be struggling with poor resources, but that might also at least partly well, be stunted or influenced by a political agenda aiming at staying attractive to large non-EU players. How these dynamics can play out, paralyzing enforcement in the GDPR context is currently illustrated in the Facebook case, where this phenomenon is fondly referred to as the so-called Ireland torpedo in the privacy community due to the Irish Data Protection Authority having jurisdiction over the Silicon Valley Big Five as a result of the one-stop shop principle. So I think one takeaway is the experiences with GDPR in cross-border cases are not particularly promising, that the cooperation mechanism will be a game changer in reining in global platforms, plus whether the Commission's role as enhanced supervisory authority over very large platforms will survive the draft remains to be seen. And as it is in the GDPR, it didn't. This puts a spotlight on the other category of enforcement, private enforcement through representative actions. As Hans already pointed out, Article 72, by way of amending Annex 1 of the new directive on representative actions, grants consumer organizations standing to launch representative actions aiming at injunctive relief and redress. And when we take a look at the past 10 years of consumer law legislation, from the GDPR to CPC to Omnibus Directive, this regulatory approach is absolutely in line with the general policy of the European co-legislators. They have settled on complementing public with private enforcement mechanisms in order to ensure an adequate level of enforcement that aims at preventing over as well as under deterrence. And I would like to strongly support that view. Referencing GDPR again, we've seen how injunction lawsuits launched by most of all German and Austrian consumer organizations in high-profile cases were at the forefront of instigating case law, pushing for decisions of national Supreme Courts and the European Court of Justice to issue their opinions on legal issues. Therefore, I do believe, and I'm in line with Hans there, Article 72 does provide a crucial tool, both in order to put a quick stop to infringements, as well as to provide a fast-track lane to gain legal certainty on how DSA provisions are to be construed, which of course benefits all involved parties. However, this function of private enforcement for now is basically limited to injunctive actions. The new redress action under the Representative Action Directive would require claims of damages to be granted to individual injured parties without a comprehensive set of rules on the liability of platforms for violating especially the due diligence obligations under Section 3. It was already mentioned before, Article 22, Article 24. This redress mechanism can neither contribute to make sure platforms play by the rules, nor is it able to enhance access to justice for individuals. We've heard about it extensively just yesterday in Christoph Busch's talk. The liability of online platforms is not targeted by the draft at all. So in my opinion, it would be of significant importance to create a uniform and EU-wide legal framework instead of leaving this crucial piece of platform regulation to be governed just by national law. Focusing on our session's topic and the enforcement side of things, this is especially also true when it comes to the interplay with EU-wide instruments of private collective enforcement, which is talked about. I've already, I think, over-exhausted my share of time. So on a final and more positive note, in the past 5 minutes, in the context of our session's topic, I focused strictly on the shortcomings of the proposal. However, and this is also important, it has to be stressed that these initiatives for a reform are a considerable step forward towards creating a more competitive and fair global market for digital services. I think it is important to also highlight that. That being said, there is space for improvement, and I do hope the most pressing issues just mentioned will still be addressed by the co-legislators. Thank you. I'm looking forward to the discussion.
Thank you very much, Petra. Hans, do you have any response to the comments? Otherwise, we can also pass to the audience's questions.
Well, I had my say, and there are interesting questions in the chat. Sorry, Petra, but we will find another occasion, I guess.
Absolutely, no problem at all. In that case, I would like to pass the floor to Annette from the previous session. She's patiently had her hand up. So, Annette, can you unmute your microphone? Hello, Annette. Okay. In that case, while we're waiting for Annette, we might pass to the next question that's in the Q&A, which comes from Gerard Spindler, again from the previous session. So he mentions, so he mentions, and I guess this is specifically directed to you, Professor. So he says, concerning the Know Your Business customer case, why can't we qualify the obligations of the DSA as protecting individual interests under in parentheses, under German law section 823 of the BGB?
Well, I'm very much willing to do precisely that, but first of all, this requires that all national legal systems have such an interface where you can put into such obligations, and moreover, at least German law is not the very best example for that, because obligations can also be qualified as purely market rules, purely market practice rules, and then don't grant a claim for damages. And by the way, at least some German lawyers would also consider tort law exclusively for consumers, which would end up, at least for the business, the Know Your Business customer rule, slightly strange. And therefore, finally, I think at least this rule should qualify as the Schutzgesetz as protective norm, also protected by tort law. But that's my personal assessment, and I'm not so sure whether everyone would follow, and I'm not so sure whether it is really a good model to leave it to the rather elaborated disputes within the national legal systems, whether there is a claim for damages or not.
If I may add, I also absolutely would agree with it's better to actually have an express clarification on that, and I think it would absolutely be possible doctrinally to qualify as this protective statute also under Austrian law, Article 1311 of our civil code. But we also at the same time see that the Austrian Supreme Court is more likely to actually follow that argument, and the German Supreme Court, at least as the cases are concerned that I know, is quite reluctant to come to that conclusion. When we look also especially at the development of financial market law in the past, also right now, most recently in the Volkswagen case, of course, like with qualifying European statutes as the protective statutes under German civil law, I think that is not just highly disputed within the scholarly community, but in the end, the German Supreme Court is not very likely to follow that approach.
Thank you for your answers. There's actually a sort of ancillary part to this question. Perhaps if you have already answered it, but he says, and moreover, what about private international law of the provider obligations under DSA? Does the market location principle apply?
Well, that's something all conflict of law experts very much like, the relation between the general market location principle, in particular of the old e-commerce directive, to the beauty of all conflict of laws. I avoided this mainly by taking a consumer law case, and therefore I felt safe. But outside, this is precisely the question, whether market location principle prevails or Rome 1 or Rome 2. Books are full with that. Certainly no clear answer. I can understand that this piece of legislation leaves as a market location principle in the e-commerce directive untouched, but at least that's another building site you are rightly pointing at.
Yeah, so I have nothing to add to that. I do believe also in the consumer protection side of things, we are safe because here we have the international private rules, but otherwise, yeah.
Okay, thank you very much. Well, in that case, we are right on time. But we can also take our time if Hans, you had any comments that you would like to share from Petra's presentation. Otherwise, we can also go to our coffee break as well.
sorry, I do not want to keep you away from your coffee break. And I think it's rather tiny work what to do in this precise piece of legislation in order at least to improve the situation, because no one can seriously now suggest that a general basis of private law liability for damages should be introduced into this piece of legislation, and therefore it is a little bit fine-tuning here and there, and that's perhaps I have some ideas, but that's much too complex for the last minute before coffee, I would say, but I don't think that's what Petra thinks.
Excellent. Well, in that case, thank you very much for both of your presentations. They were extremely enlightening. In that case, so what we now do during our coffee break is that we will use the GatherTown portal. So this a link to this can be found in the chat, but also it's a link is in the email that you would have all received earlier today for the conference. So this is a virtual space which allows people to meet other conference attendees and strike up conversations. And basically, when you're connected to it, it will be a virtual space where you can use your arrow keys to move your specific avatar or character around to different rooms where other members of the other attendees will be. And you can use your microphone and camera to start a conversation there. There are also some basic instructions in the chat should anyone wish further clarification or further information. So thank you very much to our presentation, to our presenters, and I hope to see you in GatherTown.